Good morning, good afternoon, good evening. I hope you're all doing well. I haven't been live for a few days. I didn't even come live to discuss the closing arguments, did I? It occurred to me when I was setting up the live to this that I did intend actually to do a live covering closing arguments, but then I don't know, it just went out my head. But yeah, Alan Jackson was absolutely astonishingly good. And Hank Brennan was lackluster and desperate. That's my summary of the closing arguments. But if you're on the other side of the coin and you believe that Karen Reid is guilty, then of course you're going to think that Hank Brennan did a sterling job. But seriously, he really didn't. He really didn't. Anyway, how many hours now are we into deliberations? I think it may be 15. I didn't clock the time that they finished on. 14 or 15 hours anyway. And yesterday, I truly thought we were going to get a verdict. I was so excited. I thought it's so close. They are so close. All they're discussing is the OUI. Now, the OUI is new. It's as part of count 2, manslaughter. And last year, they didn't have OUI as an option. And the way that the OUI is worded, it's literally just driving under the influence of alcohol, like drunk driving. That's it. That's all. Doesn't have to be anything to do with killing anybody. And I think the defense requested it because they've taken on board the things that the last year's jury said, that if there'd been an OUI option, maybe they could have reached a verdict. Because I think the jury last year felt that they needed to punish Karen, but because there wasn't an OUI, they hung. And it's deja vu. This is last year all over again. And I just was like, oh, I'm so angry at Bev Canoni. So angry at her. Because I think the jury were close. They just needed the answers to the questions that they asked. And I don't see any reason why she couldn't have just answered them. I mean, she did in part. But I think she's confused them more. And she's trying her best. She's trying her best for Hank Brennan. I can't see any other conclusion. That she's being deliberately confusing. I don't know. I just don't know anymore. But I'm so hoping that we get a verdict today. Otherwise, we're going to trip into next week. Court's closed tomorrow. There's some kind of federal holiday. And then it's somewhat unclear as to whether court is closed on Friday as well. No one seems to have an answer for it. That some people are saying that court is closed on Friday, and some people are saying, no, it's open on Friday. But assuming that there's no verdict today, we may well be tripping into next week. Well, actually, we will, because the jury won't know it yet. Like the current jury won't know it yet, because they can't just hang. Like, if they can't reach a resolution and they come back and say they're hung, well, they don't just go home. You know, she doesn't just declare a mistrial and they go home. There's all the palaver that has to come, that they get sent back to try again. And then if they're still hung, then they get the Chewy Rodriguez, whatever that is, instruction. Do you remember all this from last year? And then after the Chewy Rodriguez, if they're still hung, then she'll declare a mistrial. So the jury might not know that they can't just hang and have done with it, that it's going to be days. It's going to be days unless they can sort it out. And I really hope they're not just hung over the OUI, because that would be, it's heartbreaking. It's absolutely heartbreaking. But based on the questions, it honestly seems to me that they're done and dusted with any belief that John O'Keefe was killed by Karen Reid, having been struck by a Lexus. The way that the questions came out, I can't interpret it any other way. So yeah. Anyway, who's in the house? Queen of Ravens. You got a meeting at 2. Well, yeah, that'll definitely be it. Yeah, when I peg my washing out, it always rains. I can guarantee. It's that kind of thing, isn't it? You can guarantee it. I think we are close, but I don't know. Hello, Angie, baby. That's not something that I've considered. Can't understand why at least 75% of the men in Massachusetts are bald, while 99% of the women have such full heads of hair. Just an observation. I can't say I've noticed, but I will now. I will now. Yeah. Kim Jong-Kanoni. Great name. Yeah, Kim Jong-Kanoni. Hello, Mimi. You got Patrice. Yeah. Hopefully she walks away from this nightmare. Hopefully. I don't know. I don't know. Yes, please let us have a verdict today. Sweating over the OUI. Look, if they are genuinely just hung over the OUI, if I was a juror and Bev Canoni had given me a bunch of confusing answers, I would be just like, sod it. She's been punished enough. Not guilty. Not guilty on all charges. That would be me. But then again, it only takes one person to hold out, doesn't it? It only takes one person to hold out. Hello, McKenna. Well, hopefully not. Hopefully this is just spirited debate and they're going to sort it out today. You know, they've gone home, slept on it, and hopefully they come back clear and able to get it done today. It is lovely weather. It's going to be boiling tomorrow, apparently. Right, by boiling, I mean like 80 degrees Fahrenheit, which to you, some of you, I know, is just lukewarm. But for us in the UK who are not used to it, 80 degrees is like we're dead. Like we're practically dead. Like the whole country comes to a halt, we're dead. You get half an inch of snow and the country comes to a halt, or you get a hot day and the country comes to a halt. Hello, Dawn, Jackie, Lisa. Who else have we got in here? Yeah. No one seems to know. Even the journalists don't seem to know. They just don't. Hello, the quiet observer. Yeah, that's the summary I can come. That's the only thing I can come up with. They added the OUI after Larry, the DUI guy lawyer, spent a day with him. Really? Okay. Interesting. Hello, Ginger Snap. If anyone thinks Karen is guilty, they are delusional. There's plenty of people still out there. Yeah. Happening all over again. It is, Joanne. It's the jury slip. It is. It's the jury slip, the count 2 verdict form. That's the thing. That's the thing that got them last year. And it's happening this year as well. All right. So for those who didn't hear the questions, here they are. Oh, my video's done. I've got a video on Claire Bell, the missing toddler from Quebec, that's going to come out straight after this live stream because just got the notification that it's uploaded. Okay, this is these are the so there was 3 questions, and then it got really confusing because she told them to come back at 1:30, and it was like, why do they need to come back at 1:30? And then she read out this other question that apparently came in before the 3 questions that she'd read out before the lunch break. It got really confusing. So the jury basically have wasted probably 2 hours because they just sat to wait for the answers to the questions, and then they got answers to 3, and then it was lunch, and then they get the answer to the 4th one, which basically is no answer at all. So they've wasted a bunch of time. But that's this court all over, isn't it? Okay, these are the 3 questions.
Questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.?
Oh, that was beautiful. I hadn't even considered that. I had not even considered that. What a great question. And none of them could answer. Like, the lawyers couldn't answer it. The judge couldn't answer it. So she concluded that they should make their own mind up. That they've got all the information, they've got all the evidence, and they should make their own mind up. Because it wasn't on the indictment. And of course, it's obvious. Now they've said it, it's obvious that if the OUI is relating to her driving at, leaving the waterfall and then going to Fairview and then going to Meadows, so, around that 12:30 mark, well, that's one thing. But then she could have gone back to Meadows and been drinking. And it's something that Alan Jackson said. I think it was Alan Jackson. I don't even know whether it was in the closing or whether it was some point during the trial. He said, they don't know whether Karen had drinks when she went back to Meadows. Like, she was upset. Maybe she just was drinking there. And maybe at 12:30, she actually wasn't over the limit, because everybody who saw her said that she was acting perfectly normally. There was no, no apparent intoxication. She clearly was drinking, but would it have been enough to make her over the legal limit, 0.08? And that's a very good question. However, if it also related to the 5 a.m. when she drove out of Meadows to Jen's on Country Lane, if it related to that, well, there's no opportunity for her to top up her alcohol levels, is it? So if it related just to the 12:45, I think they'd have gone not guilty. If they'd have come back with the answer that it's related to the 12:45, 12:30, 12:45, then I think they would have said not guilty. At 5 a.m., obviously, she's no opportunity because she's in the company of people. From 5, she's in the company of people. So if they said they could also include 5, then they could have gone guilty on the OUI. That's the way I interpret it. Might not be the way the jury intended it interpreted, but that's the way I interpreted it when I heard that question.
The second, are video clips of Karen's interviews evidence? How can we consider them?
Oh, I was cackling. Oh, dear. Hank Brennan. He hinged everything on the Karen clips. He was so proud of all of his Karen clips. Thought he was so clever. And the jury were confused that were these even evidence? Do we even consider these clips? Hank must have felt like just like hiding under the desk. But the jury didn't even know whether they were evidence or not. But they got an answer to that one. The answer to that one was, yes, they are evidence. I mean, they are. They were played in court. They're in the court record. They are evidence. So they can consider them. There was a debate as to the wording of the answer. And Alan Jackson wanted her to include the words, if any. So, give it the weight you feel. Any weight you feel, if any. But she didn't go with that. But I think that's clear enough anyway to the jury. So they got an answer to that one.
And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Read. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
I think it's very clear. I think it's very clear what they're asking. Because the verdict slip is so confusing, they're not clear that if they tick guilty to anything on there, even the OUI, then they could well be saying she's guilty of manslaughter, even if they didn't intend it. That's what they're asking. And the answer is no. The answer is, if you convict on the OUI, you say guilty to OUI, then it's the OUI. That's it. That's all. Now, one thing she did do, she relented and gave the jury some additional instructions. The instructions that the defense wanted her to give them right from the beginning. Have a little bit of text after each one saying, if not guilty to this one, go to the next one. And then if not guilty to this one, go to the next one. If not guilty to this one, go to the next one. Now, the danger, however, is if they can't sort this out and they hang on count 2, and it's all about the OUI. So they've all agreed, let's just say they've all agreed that Karen Read is not guilty of manslaughter. She didn't hit John O'Keefe. So none of the other charges on that count 2 are relevant, because everything else, apart from the OUI, requires Karen to have hit John O'Keefe and killed him. Just all the way they're all worded. It's only the OUI, which is just drink driving. Nothing to do with killing anybody or hitting anybody. It's just drink driving. If they hang on that, because it is part of count 2, it's not a standalone charge, because she wasn't indicted on that. She wasn't indicted for OUI. So they can't put it as a standalone charge because she wasn't indicted for an OUI. It's just an addition to count 2 as one of those lesser included charges. But it's still all part of count 2. So if they hang on the OUI, even if they've all agreed between themselves that Karen did not hit John O'Keefe, but they hang on the OUI, it means they hang on the whole lot. So Karen Reid could then be tried again for manslaughter. And it's exactly the same situation that we were in last year. Exactly the same. All right, so we do lunch. And then we find out that there is another. Is that lunch? Is that after lunch? It's not got the little thingies on it, little chapters. Okay, I think this is coming back after lunch. This is when we learn that there was a 4th question.
Please be seated. Court is in session.
All right, so I'll see you at sidebar so we don't do this part in open court.
See you in sidebar, okay.
It's a theoretical question.
I needed to read the question. I don't know how this can be deemed a theoretical question. I honestly don't know how.
Jim, can I have that question, please? Thank you.
I don't know how this is theoretical.
All right, so as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at side.
That is exactly how the jury hung in trial 1. They said between themselves, said she's not guilty of murder. She's not guilty of count 3, which is leaving the scene of an accident, so hit and run, basically. They could have given their verdict slip in for each of those counts, tick not guilty for both of those, and it would have meant that the Commonwealth could not try Karen again for 2nd-degree murder or leaving the scene of a motor vehicle collision. The only thing they were hung on is manslaughter, and it was like 6 and 6. That some of them thought she was guilty of manslaughter, some of them thought she was not guilty of anything. And that's what they hung on. But because they didn't give any of the verdict slips in, that's why we're here once again, and it went all the way up to the Supreme Court, and the Supreme Court agreed with Bev that because the jury hadn't handed the verdict slips in, it doesn't matter what they say after, it doesn't matter how many of them come out and speak to the media, it doesn't matter, because they didn't give the verdict slips in. So this jury are getting ahead of this. They've already agreed between them by reading between the lines here, and I don't think you have to read between the lines very far to say they've already decided that she's not guilty of murder, she's not guilty of leaving the scene, and the only thing they're considering, and given the 3 questions previous, the thing that they're considering is the OUI. So potentially, if they don't sort this out and they decide that they're not going to give any verdict slips in because the answer that they're given is confusing, then we will be coming back for trial 3. Because it will be exactly the same situation as last year. If they don't give any of the verdict slips in, if they don't tell the court formally, officially, via the verdict slips, that they believe Karen Reid is not guilty of murder and not guilty of leaving the scene, Commonwealth can try her a 3rd time for the murder and the leaving the scene counts, as well as the manslaughter. This is how crucial the deliberations are right now. It's a bizarre situation, absolutely bizarre. And Bev Canoni, all she did was confuse them more. I truly believe if she just answered this question, we would have had a verdict yesterday. But no, it's theoretical, she says.
Bar essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The disposition is not certainly not the position for it. I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's clarity in your other questions, does this answer your question? Can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think that at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right?
What do you mean that's for a later time? The jury want to know the answer to this now. And if you're able to give them an answer at a later time, whenever that might be, you're just wasting everybody's time. You're wasting everybody's time. If you're able to give them the answer now, why wait till a later time? That's complete insanity. Now, Alan Jackson, what he's doing now is making a record. He's making a record, the record that wasn't made last year, because if they hang, they don't give their verdict slips in, and they hang again, and it becomes exactly the same situation as last year, Alan Jackson is making sure there is a clear record of how the defense felt about it. So he's doing exactly the right thing here.
Right. So this is, at this point, it's premature, it's hypothetical, it's theoretical. I understand.
Premature. They want the answer to it now. Does she not want them to reach a verdict? What is going on here? Is she trying, like she's recognised that the jury are potentially going to let Karen off? Is she trying to confuse them so that the Commonwealth can get a 3rd bite of the apple next year? If you are in the state of Massachusetts, or the Commonwealth of Massachusetts, this is your taxpayers' money that is being spent on a frivolous, unnecessary retrial where $400,000 was spent on a man painting a tail light blue and him rubbing his arm on it. That's what $400,000 of your taxpayers' money was spent on. And we have a special prosecutor and his staff who, when you add it all up, is going to be, I bet, close to $1 million. Do you taxpayers in Massachusetts want this charade to go on for yet another year? Is that what you want?
Understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this, I'll hear from the Commonwealth.
If they don't know the law, they just need to be told the law. These are 3 different counts. Yes, you can return a not guilty on one of those 3 counts or 2 of those 3 counts. They are different. They are different charges. There are different indictments. So yes, they can, but they don't know that.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
That's bullshit. That's bullshit. That's not the law. I'd like to know which law she's referring to, because these are different indictments. These are different counts. So they can return a verdict of not guilty to murder and then go on to consider the rest if they would like to, or to say not guilty to counts 1 and 3, but we can't decide on count 2. They absolutely can do that. And if she's saying this is not for this time, that she'll consider it at a later time, shows me that, yes, she can answer it. She just doesn't want to answer it. She doesn't want to answer it.
Well, I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think.
Such as?
The first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can't answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, John?
1 minute.
How about 1 minute? You guys are 10 minutes late.
They were not 10 minutes late. They were not 10 minutes late. She's lying. They weren't 10 minutes late. And even if they were 10 minutes late, how many times has she been late? But that's not the point, because they weren't late. Everyone was in the court for 1:30. She told them to be back at 1:30. Everybody from the defense was back before 1:30. She's lying.
1 minute, thank you.
So to say, oh, well, you can't have 2 minutes, you can only have 1 minute because you were 10 minutes late, that's a lie. Listen to her huffing. She's a piece of work, I'm telling you. She's a real piece of work. It's disgusting, really is. She's always the one that's late, I know. When has she started court on time? During the trial, how many days did she actually start court at 9 a.m.? How many times did they come back from lunch at the time?
Just with a very slight tweak with the court's language, I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in the court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict.
Exactly.
So I think saying, I can't answer this is sending a false message to the jury.
Exactly.
If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question not a question I can answer.
At
That
this
does the
time,
same
at
thing.
least
Is there an
it's-
objection? I understand, Mr.
It's
Jackson.
important to have the clause at this time.
Is there an objection to me putting, this is a theoretical question, not a question I can answer?
No objection.
Yeah, Brandon, yes, Mommy, yeah.
And allow the court to finish writing, but at this point, that is over our objection. I don't.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I
Okay.
think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't tell you to ignore anything, Your Honor.
all right, we are all set. So let's send this in, please.
All right.
Unbelievable. 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 All right. Ronnie, the juror from last year, was on Banfield last night. So I just want to play what Ronnie said about this situation. Now, Ronnie has done interviews. He's done several interviews, Ronnie, the juror. He's been quite outspoken. So I just want to play you this little clip here from Banfield on News Nation. Where do you put her on the Gull scale now? Where do I put her on the Gull scale? Well, I still maintain she's not as bad as Gull because at least we're able to see this trial. But in terms of her decision making, I think she's hot on Gull's heels for decision making.
He was one of the first jurors. Ronald Stanislaw, welcome back to the program. Good to have you, especially on a day like today. So what's your gut telling you when you heard about the questions the jury was asking?
Yeah, like they're having the same exact situation that we had last year.
I get a pit in my stomach when I hear that because, you know, it's expensive. It takes a lot of people, a lot of time. It takes people like you and these new jurors and your fellow jurors out of their lives for weeks upon weeks on end. And no result, like a real waste of time. Would this be something that would make you angry and frustrated?
It's very frustrating for a couple of reasons, but hopefully it will make a difference this time around. And one of the biggest problems that we had last time is we did not know to actually submit the verdicts for the first charge and the last charge. So as long as those are submitted, then the mistrial or the hung jury would be only on one count as opposed to all counts. And that may make a difference. But again, we didn't do that in the last one, which was the major problem. This time around, if they submit that, I can understand that. And I think it's also would be clearer now that that second charge has different factors or different types of levels. Unfortunately, that is where we got locked in last time again, where not everybody could agree on one particular charge.
So was it more a case where there was a division over the guilt or innocence, or was it more a division over, I don't understand the jury form, and somebody on the panel thought one way and someone else on the panel thought another way about the instructions themselves, and you just couldn't come up with an answer? Because that's what it feels like with this jury. Was that the same for you?
It's actually, in this case, it seems like they're asking more of the appropriate questions to kind of fill in the blanks, etc. But that was exactly our problem.
Yeah, they are asking the appropriate questions, but they're not getting answers. They're not getting the answers they need to move forward. So, yeah, they're asking all the right questions. They're asking the questions that the jurors last year didn't ask. But now they're in a situation where they're probably more confused. They're probably now arguing amongst themselves as to what they're going to do next, how they're going to move forward. The deliberations in terms of, you know, the fate that of Karen Reed is now secondary to how do we interpret the answers to these questions? And we still don't understand. Therefore, what should we do? I'd tell you what I'd do. I'd be like, well, sod this, I'm going home, not guilty. Not guilty, who's with me? Not guilty on everything, who's with me? That would be me. I wouldn't put up with this shit anymore.
Problem before, but we didn't ask the questions. So now it seems like they're willing to fill out the forms accordingly and follow the instructions accordingly.
But they don't know. They don't know that they can do that. They don't know that they can do that. They were told this is not a question that she can answer. That's what they were told. So they're not going to ask again because they've been told this is not a question she can answer. They're not mind readers. That's why Alan Jackson was trying to say, well, at least put in, I can't answer it at this time. At least give them, the option to come back and ask again or reword it, because it seems that she deems it's theoretical if they say the word if. It's not theoretical if you use the word if. You say, how do we fill the form in if we've agreed not guilty on 2 counts? How do we record our verdict? I think is what they need to ask. They need to reword it to say, how do we record our verdict? So that at least then Alan Jackson can argue that this is a recording. It is recording. It's not theoretical. It's a recording question. How do we record our verdict? But the jury doesn't know that. So they'll be sitting there now debating on what to do next. Unbelievable.
Other problem is just the charge itself. It's hard. We were deliberating a lot on which charge is appropriate in terms of the levels, because that second charge of involuntary manslaughter actually has a different layers, and that's where we were stuck on, and we could not agree on one particular charge.
But this jury, it does appear, as they're concentrating on the OUI, it does appear that they've got further than this jury. That's the way I'm reading between the lines. That they've got further than that, which is good. So I hope this doesn't set them back, to start reconsidering other things.
It must be frustrating for you watching this, knowing everything they're going through, having gone through it. But it's even more frustrating for people who don't know the system the way Judge Cannoni knows the system, to hear that she won't answer the questions. It's not that she's mean. It's not that she doesn't care about the jury. It's that she's limited in what she's allowed to say.
She's limited, but she could answer that question. There is no law that says she can't tell them how to fill in the verdict slip. There's no law that will preclude her from doing that.
Is it frustrating for you because you know what needs to be said and what she cannot tell them?
She can tell them. She can tell them that she could have even said that, theoretically, you can fill in. She doesn't even have to say not guilty. She can say, theoretically, you could fill in 1 or 2 verdict slips and record those verdicts whilst not filling in. Basically, you can give a partial verdict because each of those counts, 1, 2, and 3, are separate indictments. They are separate from each other. So yes, of course, they can record one and not record the others if they so wish. What they need to know is, can they do that? Legally, can they do that? They can. They can.
Yeah, it's very frustrating because now we're stuck in the same situation as we were before. But like I said, I think what is better now is there are better instructions in with regards to making sure that the separate charges are signed and not guilties are made for the two charges of the second degree murder and leaving the scene of an accident. And that is signed by the foreman, which would alleviate some of the issue that we had last year where we didn't sign anything at all. No forms were signed, so that didn't go on the books as not guilty for second degree murder and leaving a scene of an accident.
But that's exactly what the jury were asking about. So we could easily be in the same situation that this jury were in last year, because she has not answered the question. She's told them she can't answer that question. So technically, they could believe they're doing the right thing by not recording anything. They could literally believe that that's the correct course of action, that if they can't decide on all three counts, they shouldn't record verdicts on any of them. And if that's the case, and they hang, and they're given the Chuy Rodriguez instruction, and they still hang, and they come back again, hung, that's a mistrial, and Karen Reid could well be in the same situation last year, being tried a third time for second degree murder. That's exactly what Alan Jackson, or why Alan Jackson is getting everything on the record just in case. So it's absolutely frustrating. It's my blood was boiling. I was so excited, thinking they're close, they're really close. And then we get to this fourth question, and Bev does a Bev classic, a Bev special, and the jury have probably wasted a couple of hours waiting for answers, and now they don't have the answer that they need, and they are potentially going to think they're doing the right thing by not recording any verdicts and just saying they're hung. That's terrifying, given that the thing they are likely to be hung on is nothing more than an OUI, is nothing more than a drink driving. That's how terrifying this potentially is now. I don't think he says anything else.
Right, because then there'd just be one charge left. I only have a few seconds left, but I just want to ask you this question. Ronald, did you like Karen Reid, or did you have no opinion of her in the courtroom?
I remained indifferent.
It's interesting. Ronald Stanislaw, thank you so much for being on. I really appreciate it. Maybe we'll talk again as soon as we hear what this jury is going to do.
All right, okay, well, there we are. So what do you reckon? I'm going to do a quick poll, 2-minute poll. Do you, can't spell you. Do you think we'll get a verdict today? Yes or no? All right. Just let that rumble on for just a couple of minutes. I sincerely hope we get a verdict today. I can't imagine how Karen is feeling. Like, if we're on tenterhooks, if we're on pins, I can't imagine how Karen and her family are feeling right now. This is especially if the thing that they're going to find her guilty of is nothing other than an OUI. She's been punished enough If all the jury believes she's guilty of is an OUI, she has been punished enough. And just give her the not guilty. Just let her go and pick up the pieces of her life. She's lost everything. She has literally lost everything. She's had to sell her house. She's lost her career. She's not been able to mourn John properly. Her reputation's been shot to pieces. She's lost everything. And she's now got to pick up her life again. And she's been punished enough. She really has. And I can imagine that, because if she's found guilty of the OUI, I can imagine that Bev will give her the very highest sentence she can, because she's just mean. And she'll want to punish Karen. She doesn't like Karen. She doesn't like the team. She's spiteful. And I don't know. Yeah, the relationship with John's niece and nephew. Yeah. Yeah, and yeah, she also has to face a civil lawsuit from John's family. Exactly. Exactly. I don't know how far they'll get. If she's found not guilty, I don't know how far they'll get. Now, I know that, you know, it's a different system, like the civil system. But how far they'll get for wrongful death, like, she'll have a very, very good defence that, you know, the jury found her not guilty of anything to do with John's death. So how can you say that she should be financially upended? I mean, what more does she have left? Honestly. I mean, what do they think that they're going to be able to get from her? You know, it's it's just spite. It's just spite. I know it's naughty, but if I was a juror, I'd do research into how to complete the form and make sure we could get in not guilty verdicts if needed. So would I. So exactly, I would. But I hope they don't tell anyone. I really hope they don't tell anyone. Don't know what an OUI is. It's drink driving. Operating under the influence of alcohol. So it's like a DUI. It's just called an OUI in Massachusetts. We just call it drink driving here. All right, I'm going to end my poll. Let's have a look. I think we'll get a verdict today. Oh, you're more optimistic than I am. 76% says yes, 23% says no, and 1% has just disappeared. I hope we do. I'm in Delphi trauma still, so I can't think positively about anything to do with courts and trials. How on earth did drink driving cause John's death? Makes no sense. Yeah. Yeah, it doesn't, does it? But I think the defence wanted it put on because they know what the jury thought last year. So they wanted it put on. Just in case that you know, there's jurors who feel that Karen needs to be punished for drink driving, but they don't believe that she did anything to John, which is why the jury asked the question, if we find her guilty of an OUI, does it mean that she's guilty of the whole thing? So would they inadvertently, by saying guilty of OUI, inadvertently, not meaning to, convict her of manslaughter? Because it's on the verdict slip to do with manslaughter. So it is really confusing. It's really confusing. So I would say, you know what, to err on the side of caution, let's just go not guilty on everything. Even if you believe that she was drink driving. Well, the whole of Canton seemed to be drink driving that night, so she wasn't doing anything unusual, and she didn't cause any anything untoward, did she? And it's shaky as it is, because she wasn't breathalyzed, she wasn't tested at the time. She wasn't breathalyzed or tested until 9 a.m. So the level of alcohol that they believed she would have had in her system at 12:45 is a theoretical one. And they've no idea what time she had her last drink, which is why they asked the question, does the OUI relate to 12:45 or 5? So, all right. Yeah, the OUI time of 12:45 is weird. It is weird. It is weird. I think it's a layover from last year where they thought she got back to Meadows at 12:45. So it's basically when she ended the first stint of driving. Like, she was already back at Meadows at 12:45, but she was back at Meadows at 12:36. But by the time she probably turned off the vehicle, given that her phone probably connected maybe a couple of minutes before she actually turned off the vehicle, then you're looking at closer to 12:40 when she actually turned off the vehicle, because you can get done for drink driving even if you're not actually driving. If you're sitting behind the wheel of a vehicle and you turn the engine on, so you're not actually driving, you just turn the engine on, you can still be done for drink driving, because you still, once the engine's on, you are still deemed to be operating a motor vehicle. Even if, like, the handbrake's on and you're not pressing anything, you're not doing anything, if the engine's on, that's it, they can do you. They certainly can here in this country anyway. So by the time she actually turns the vehicle off, that's when she's deemed to have finished driving. So it's very smart of the jury to think, well, she did drive again at 5. She went to Jen McCabe's at 5. And Kerry Roberts. They went and picked Kerry Roberts up. And didn't they? What did they do? I can't remember now. But yeah, she drove to Jen's anyway. And that second stint of driving has nothing to do, absolutely nothing to do with John O'Keefe's death. But because there was no time on the indictment, it's a smart question to ask. But if that's what if that's all they're hung up on, I really hope that after a good night's sleep and maybe some sneaky research on how to fill in the verdict form, they can come back and deliver a verdict today. So they're going to punish her for going looking for John. Well, technically, yeah. Potentially, yeah. But she's been banned from driving for 3 years. So what are they going to do? What are they going to do? But I'm quite sure if that's what they find her guilty of, Bev will try her best to make her life as unpleasant as possible. Wasn't Jen the one driving? No, not when Karen left. If you remember, Karen left Meadows, bumped John O'Keefe's car, which is how she cracked the taillight, and then she drove to Jen's. Now, it's only a very short journey. Very short. One Meadows to Country Lane, you're looking at maybe a mile and a bit, maybe. But it was Kerry Roberts that drove to, or was it Kerry or Jen that drove to Fairview? I can't remember whose vehicle they got in. Was it Jen's? Kerry's? I can't remember. It doesn't really matter because she did drive. Yeah, they drove back to Meadows and she left her car there. Kerry was driving at 6. So she drove from Meadows to Jen's and then back to Meadows. And then Kerry Roberts drove from Meadows to Fairview. So you guys saying Kerry, yeah, you're right. It was Kerry who was driving. All right, guys, I'm going to go. So I've got an hour to kill until we basically sit for another day. Are you doing what I'm doing? I've got the court on like at my phone. I just have the court open on my phone. And then every time I hear a noise, I like freak out. Like I'm trying to keep myself busy. But I was meant to be busy yesterday, and I was thinking, oh, that's good. I'm going to be busy. It's going to pass the time. And then it turns out that I didn't need to do what I had to do. So I spent the entire day waiting for a noise to come from my phone. Right, it's a complete waste of time. It's a complete waste of time. So, watching Netflix, trying to relax, listening to Melanie Little stream while working. I like criminality. You know, Teresa. I dip into her quite a lot. Because she thinks a lot like me. She has a lot of like similar opinions to me. So I like listening to Teresa. So I dipped in and out of Teresa's live like the whole of yesterday. I was in and out. Anyway, I'm going. Thank you all for joining me. Hopefully, this will be the last time, the last time we have to worry about the Karen Reid case. Hopefully, we get an answer. Hopefully, it's a good answer today, and then we're done. We're done. We can draw a line under it. We're done. Okay, so there is going to be a video about the missing toddler, Claire Bell from Quebec, in the next 5 to 10 minutes over on Michelle After Dark. The video is ready to go. Just all I need to do is press publish, and then you can go and watch that. She's still missing, and it's bad. I think that's bad. All right, guys. Thank you, mods. And I shall see you. Hopefully, I won't see you on this channel tomorrow. Hopefully, we won't need it. All right. Bye, guys.